We're back one final time today with the candidates for state Supreme Court. Joining us now is Judge Michael Screnock. Governor Walker appointed him to the Sauk County Circuit Court in 2015. Before that, he was an attorney with Michael Best and Friedrich, the law firm where he helped defend Act 10, the Republican law that curtailed collective bargaining in Wisconsin. He spent several years in city government before attending the UW School of Law. Judge Screnock, welcome back to Up Front.
Thank you for having me back. I appreciate it.
Well, you've talked often in this campaign about you being the candidate who is committed to the rule of law. And a couple of your opponents, one of them, Tim Burns, is talking about his politics, and Judge Rebecca Dallett has talked about her values. The question I have is, should people in an election of this kind know something about your core beliefs or your value system?
Well, I think the people should know how each of the candidates intends to actually operate from the bench. And so I am committed to the rule of law. I'm committed to setting aside whatever personal feelings I have about an issue or a party in deciding the case purely based on the facts and the law. And for that reason, it really is not important to the people as to what my personal beliefs or political values would be, because it would be unhelpful for them to select my candidacy based on those issues. Now, for both of my opponents, I think they've signaled that their values do matter to the work that they intend to do on the bench. Mr. Burns has made it abundantly clear that that's why he's running. Judge Dallett has been a little more guarded with her words, but as you indicated, she's been running on her political values, and she's said some very specific things about clean air, clean water, the full funding of schools, workers' rights, women's rights. And I think it is hard to understand why voters should care deeply that she cares about those values and not think that they would then find their way into her decision making, because it's such a hallmark of her candidacy right now, and she's using those values as reasons to encourage people to vote for her.
I want to get your response to what your opponents have said about you, and it's essentially that you would be a rubber stamp for Governor Walker and Republicans. They cite your work on the Act 10 case. They look at the parts of the Republican Party infrastructure that seem to be helping with the campaign, getting the word out about you. Conservative groups spending a lot of money on ads in your favor. Their argument is, if you're elected, you're going to be the guy who can be counted on to vote yes to anything that the Republican legislature and Scott Walker wants done.
Yeah, and there are two different things there, and both are important. The first is the work that I did as an attorney. And the work that I did as an attorney, I'm very proud of. I did excellent work. That's the reason I was selected to work on very important matters. But I understand that the role of an advocate as an attorney is very different from the role of a judge. And now that I'm a judge, my fidelity is to the law and to the law alone, and not to either party that comes in front of me. And I am, as I said, committed to following the rule of law. When you look at the support that I'm getting in my candidacy, I don't think it should surprise people that lots of individuals and lots of groups want to see justices on our Supreme Court who are committed to upholding the rule of law, setting aside their personal feelings and beliefs, and deciding cases based just on the law. And so I've been endorsed by a majority of our sheriffs across the state. I've been endorsed by the Wisconsin Realtors Association. I've been endorsed by the Wisconsin Right to Life Political Action Committee. And those are three groups that deal in different slices of society, but all of them understand the importance of having stability and predictability in the law, which only comes from having a court that follows the law and doesn't try to change the law or rewrite it from the bench.
I want to ask you, you mentioned the Right to Life organization, and I do want to ask you, because there are people, some of your critics have said, how would Judge Screnock rule on an abortion-related case? Could he truly be impartial, given the fact that when you were a young man at the University of Wisconsin, you were arrested a couple times for an abortion protest outside an abortion clinic in Madison? Clearly, that was an issue you felt passionately about. You strongly believed that abortion was wrong. How could you rule on a case impartially, given some of those personal beliefs?
Well, if I could not, I would have to step aside. There's absolutely.
Do you think that would be
there's no doubt about
possible, a recusal, if a case of that kind came before you?
If I believed I could not be impartial, absolutely I would recuse myself. I have to. It's part of our judicial code of conduct. And it's more than just the code of conduct. Our very judiciary is founded on the principle that we have judges and justices that decide cases impartially. But people have to understand that the task of a judge in every case that comes before me involves me having some sort of a feeling about either a party or an issue or something that's going on in the case, and I have to set that aside. if you want to sign up to be a Supreme Court justice and ask the people to trust you with that awesome responsibility, you have to be willing to set those things aside. I am willing, and I know that I can do it.
A final question, and I didn't have a chance to talk with you about this last time, but this is this recusal matter in a larger sense. So there was this school of thought, an idea that justices should overhaul the recusal rules in the state and essentially say that if you were seen or hearing a case that involved a party that had given a lot of money to your campaign or supported you as a candidate, that you would automatically say, I have to recuse myself. That was not adopted by the current court. How do you feel about the fact that it was not adopted? Should it have been?
Yeah, I don't think that the petition, the specific rule petition that was advanced, I don't think I would have supported that. And actually there was a lot of...
Because of First Amendment concerns?
Yeah, because of First Amendment concerns, I think the limit that was set, the $10,000 limit for Supreme Court justices, is an arbitrary limit. And I think you run the risk that individuals or groups that care about our court. I mean, look at this race. The voters have a very clear choice in terms of the judicial philosophies of the candidates. And for folks in this state who are interested in our court and want to participate in that election, they should not be stifled in that participation over an arbitrary recusal rule, recognizing that this is a 10-year term. And so I think that it's important that, again, people understand that they need to be able to trust their justices. If you can't trust the individual justices to sit out on cases where they can't be impartial, then the entire fabric of our judiciary falls apart.
Judge Michael Skrenak, the Sauk County judge who's running for state Supreme Court. It's good to have you back on the program.
Thank you very much.
Appreciate it. Again, the primary is February 20th. The top 2 vote getters move on to the April 3rd general election. Our editorial partner, WisPolitics.com, covers the race for Supreme Court and the other statewide race this year. You'll find that on the election blog at WisPolitics.com. And I'll be back with some thoughts about voter turnout in the court elections.